Good afternoon, Senator Timothy and Representative Gonzalez, ladies and gentlemen. Thank you for this opportunity today. My name is Robert Cantell. I wish to focus my testimony today on Senate 1540, an act to reform parole in the interest of justice. I came to prison at 20 years old with a second-degree life sentence for a non-capital offense in 1977. Despite completing 27 successful furloughs back into the community from 1985 to 1987, I was not finally released on parole until 2010, after serving 33 years directly to the community. In spite of numerous nonsensical obstacles put in place by Springfield parole officers, I was able to find affordable, approved housing. Had I not had personal funds and financial assistance from family and friends, I likely would not have been released. I also found full-time employment during an economic depression, despite parole officers barring me from the local employment agency. My female parole officer said I could not use a computer or smartphone. Imagine how difficult it is to find employment without being able to submit an application online. I obtained my driver's license and a vehicle, and I was working full-time and abiding by all rules for several months until I was suddenly and nonsensically violated and returned to prison for irresponsible conduct, the mere possession of a $1.49 work tool, despite a resounding letter of support from my employer. Had it not been for overzealous, inexperienced parole officers overreacting after the infamous Sinelli incident, I would have continued to be a safe and responsible tax-paying person, supporting myself and likely living in my own small house by now, rather than an expensive burden on the state costing taxpayers about $1 million so far. I know many other lifers and others who have lived in the community on parole for years, even decades, only to be returned to custody for minor, non-technical rule violations. Many were living safe, responsible, and productive lives and should not have been returned to prison for drinking a beer, associating with another parolee, or any of another number of non-criminal actions. In most cases, graduated sanctions should have been utilized before terminating parole. I put a tremendous effort into preparing for release, finding approved housing and employment with little help from parole officers. If anything, they were a hindrance. It is a good idea that each parole condition should be reasonably related to the crime of conviction and no less restrictive than necessary. No parolee should be returned to prison for violating a condition of parole that does not result in a new charge or criminal conviction. Returning someone to prison for an arguably minor, inadvertent, and oftentimes inconsequential parole rule infraction is morally, ethically, and financially irresponsible. Thank you for allowing me this opportunity to testify in this important matter. Please vote with your hearts and minds to pass this important humanitarian bill. Thank you very much.
Robert, thank you very much.